I find it very exciting, and I'm going to borrow it and use it now, so I'm going to call it the judicial renaissance from now on. All our judicial reforms are going to be judicial renaissance. The country decided 1.7 million cases last year. The pendency is still 2.4 million. So you understand how sluggish the litigational sector is. Chinese don't like litigation. They don't like stay orders. You have to speak their language and you need to understand how to do business with China. That SAARC could be reborn with China, with the BRI, South Asia collaboration. We could start working with our neighbors with this new language of dispute settlement, enhanced trade, enhanced business. So please, for a minute, just forget the courts. Am I loud enough? Yeah. I mean, she used to come and everything changes, you see, and we see other speakers and the volume goes down. So I thought I'll just request and get the secret behind this. So, I mean, I have passion for ADR, but you guys, I mean, your love for ADR must be crazy, you see. It's 3.5 hours and everybody's here. A big clap for all of you, actually. I mean, you must be really in love with ADR, I'm sure. So, ladies and gentlemen, let me first thank IBA. I've always wanted to be at the IBA. It took me several years to get here. It's a leading institution in the country, and congratulations to Mr. Zaidi, Mr. Buland, Mr. Belgrami for setting up a wonderful institute, the EDRIC, for ADR. It's a great initiative, wonderful, and congratulations on this also. I love the title of the conference, actually, the ADR Renaissance. I think it's a great term. I thought Buland must have thought of it, or Belgrami must have thought of it, but thank you. They honestly admitted that it was Dr. Joe Chitlik who thought of it. So I find it very exciting, and I'm going to borrow it and use it now, so I'm going to call it the judicial renaissance from now on. All our judicial reforms are going to be judicial renaissance in future, because they actually talk about innovation, rebirth, creativity, and profound revitalization which is required in our justice system. So thank you for this term. I really enjoy that. Let me just, I mean, it's pretty late. There's a lot that I have to say, but let me just summarize a few things which I want to address the businesses who are sitting here. Considering that it's a business school, the leading business school in the country, I was told businesses are present today. So I just want to go on a tangent and talk about what businesses can do about ADR. And I'll come to that in a minute, explaining what the judiciary is looking at and what the problems judiciary is facing about ADR, so that you understand why you have to go ahead and do a lot of things which I'm going to tell you in a bit. So when you look at pendency, and I'm just addressing the businesses here, please, and I'm talking about commercial cases tonight, nothing else. So I want to tell the businesses of our country that litigation in Pakistan, we have, and you've heard this before, 2.4 million cases in the country, out of which 83% are in the trial court. So that's where the real fat of our litigation is. And that isn't moving. That isn't moving. The country decided 1.7 million cases last year. The pendency is still 2.4 million. So you understand how sluggish the litigational sector is and how sluggish the courts are. We're getting about 4,000 cases per month in the high courts, and we're getting about 68,000 cases per month in the district courts, and we're not getting anywhere, for which special judicial renaissance is underway. And I'm not going to bother you with that. There are a series of judicial reforms we're thinking of coming up with, which is going to talk about technology, AI, and a number of other things, so that we could sort of move the pace of this sluggishness that we are through right now. We have about 4,000 judges in the country. That needs to be taken up to 20,000 if we really want to meet the average international benchmark per capita of a judge, which is 90 judges per million. Pakistan is sitting on 13 judges per million. So that is our problem. We'll deal with that judicial aspect of it and the pitfalls of litigation and all that. I think businesses need to take an initiative on their own, which I want to address today, and that's very important for them to understand. My request to businesses is that they can get started with ADR tomorrow on their own. They don't have to wait for the justice sector to reform itself. They do not require any legislation. They can get started on ADR tomorrow. Start having an ADR panel in your businesses. Have an ADR ombudsman or a panel in your business. Have an ADR policy in your business. Why can't you do that? Why can't your company start thinking about ADR every day? Why can't you have training for your managers and train everybody as a mediator in your business? Why can't that be done? So when you're dealing with your customers, when you're dealing with your sellers, you just know how to mediate and solve the problem rather than taking it to any court for that matter. So don't come to us. Just resolve it yourself, and the companies can do it. And I'm not saying this just on top of my head that I'm just saying this can happen. This is happening all over the world. You are no more reliant on the justice system. Please do it yourself. Just have policies, just have ADR systems embedded in your company. And you can do that. You can have a panel, a board of ADR, or ADR board, or a mediator set of board inside the company which addresses issues within the company as well as with your suppliers, with your customers, and you can deal with that. This is no rocket science to my mind, and you can do it. And I'll just explain to you why this is happening all over the world. And it's not as if we've come up with something totally, new. We can use the external centers like ADRIC and others later. We'll come to them later. You can do it in-house yourselves. And I'll just tell you how this is happening in the world. And the gentleman from Singapore, Mr. Seng Lung, if I'm correct, said that this is a cultural thing that we are addressing. So I'm addressing a pure cultural paradigm shift here, please. And I think we need to, and I'll slowly get into the international circuit as to what's happening in the world, but I want you to get used to the terms, you see, which it's cultural. And I want you to understand that when we say a bird in hand is better than two in the bush, a stitch in time save 9, and a penny wise pound foolish is all about mediation at home. I want you to also understand the idioms that are there in our English language. For example, cut your losses, bury the hatchet, meet halfway, kiss and make up. Well, there you got to be slightly cautious. Smooth things over, mend fences, call a truce, settle differences, give ground, find common ground, let bygones be bygones, strike a balance. These are the words you've got to get familiar with now, please. The businesses need to start thinking on these lines. This is mediation. This cultural shift has to be brought in for you to understand. So we are talking about a pro-settlement bias. A pro-business bias has to be brought into your thinking. And companies need to think that we don't have to go to courts. We'll settle it ourselves. We are able to settle ourselves. We have a panel within our company. We have expert mediators working for us. We have employees in the company who've gone through mediation training at the ADRIC, and we can settle disputes within the company. Why are we going out to the courts? That's the kind of mindset that needs to be brought in. And I now totally change, my new word for ADR is PDR, Preferred Dispute Resolution. You do not have to go to court, please. You have to, you have no choice but to settle the matter through mediation. If it fails, it sort of escalates to arbitration. It should finish there. But if worse comes to worse and there is a question of interpretation, yes, you might end up at the courts. But no, for no other reason. So PDR is the word now, Preferred Dispute Resolution. Alternative still gives you a choice. I could go to the court or I could go to the mediator. PDR does not give you that choice. Let's seal that. You have to go for our mediation. It's a must. You have to finish it through arbitration and resolve it there. You can't just clog the courts. We're sitting on 2.4 million cases. We're clogged and the system isn't functioning. We're working on that reform, but please, the businesses are smart enough to understand that they don't need to overload the courts anymore when there is a system of doing it themselves. So when I talk about this new system, I refer to some of the companies in the world who have already done this, and that's something that most of the chief executives, prominent chief executives in the world have done it. So I refer to Jeff Bezos of Amazon, who has implemented extensive ADR processes, especially in handling disputes with sellers on its platform. It's called the Amazon A to Z guarantee, which settles these problems. Let's move on to Tim Cook at Apple. And known for his pragmatic approach to business, Cook has been instrumental in steering Apple towards using ADR. Go study those models, and they're doing it in the world. Then we talk about Richard Branson. He's amazing when you talk about ADR. In the Virgin Group, Branson has been a vocal advocate for non-confrontational dispute resolution throughout the Virgin Group, particularly in customer service sectors of the business. Virgin Trains, for example, had implemented customer dispute resolution platforms that mirrored Branson's philosophy of resolving issues amicably. So they're doing it. Then we look at Sheryl Sandberg at Facebook, and she follows mediation policies within her company. So, I mean, hello, I mean, what are the businesses doing? Why aren't they looking at all this? And why do you rely thinking that the judiciary will give you an answer to this? It's your own baby. Go do it yourself. And if you look at Jack Ma also at Alibaba, they seem to have a very strong portal where settling disputes on these. So the well-known companies, as I said, Amazon one, eBay is setting online settlements of disputes. You could do that. You could start an online settlement dispute. You need technology. You don't need laws. You don't need legislation. You need technology. You need to understand that we can settle it ourselves. Look at Google for that matter. Google offers various ADR methods to resolve disputes related to its services and projects. This includes mediation and arbitration processes. AT&T does it, IBM does it, and I'm not going into their details. Everyone has a very strong ADR policy in place. The American Express, the UPS, the Hewlett-Packard of the world, the IBM, they seem to be doing it. General Electric, they all are doing this. Toyota, for example, has a partnering program in an ADR initiative aimed at resolving disputes with suppliers through mediation before resorting to arbitration or litigation. Now, they're all here in this world. These companies are operating with their own policies. My request to ADRIC would be to help companies stand up on their own, to show them these policies so they could be self-sufficient. They come to you as an external ADR system later, once they fail and they're unable to do it. So handhold companies to be self-sufficient, self-reliant in the business of ADR, and that would be perhaps the future, as I see it, could be the way out of all this. For example, Intel has a very strong variety of ADR techniques that it uses in its own company. So these programs are typically part of a broader effort to create a more collaborative workplace culture and to handle external business disputes more amicably. The use of ADR by such companies often leads to faster resolutions, and you don't have to go to anybody else. So that's one set of submissions that I wanted to make, was that the companies, please get self-reliant. Just go pick up all these companies that I've referred to, find those policies, announce a policy tomorrow in your company called the ADR policy. Get a hold of some people, tell ADRIC to train some of your managers and get going. I mean, I think there is no waiting on this one. You don't have to wait for anybody. One. Number two, I would like to, as Justice Jawad referred to, climate change. These are serious things that are going to happen to companies. So climate change is going to seriously affect companies and businesses in numerous ways, influencing operations, supply chains, regulatory compliance, and there will be operational disruptions, there will be supply chain challenges, and there will be regulatory and legal challenges which will have financial impacts and other reputational risks that the companies will face. So you need to also tailor an ADR soon in dealing with those climate change issues which will arise sooner or later. And ADR would be the best climate change alternative to deal with those issues at that time. Climate finance is another big thing that's coming your way, the businesses, and I refer to that, that refers to financial resources allocated towards climate change mitigation and adaptation activities. These projects will bring disputes also. So climate change and climate finance will bring disputes, so please get ready. The businesses ought to take position on ADR internally to understand these issues, because in this you'll be meeting global partners. ADR works for them, ADR works for you. So please try to think of ways where you could have agreements with your suppliers or your partners which embeds a clause of ADR, in-house ADR, it's no rocket science to my mind. And you can have the flexibility of resolving it right in your office. You could have a floor or an office or a separate room called the ADR panel, which could be totally neutral people sitting in your company trying to resolve your disputes. Moving on to business schools, and my request, and I see it at IBA, and I think the ADR curriculum needs to get blended into your program, curriculum. It's important. At the law schools, we're talking about it, and I'm not talking about the judicial reforms. We're telling the law schools to start talking about negotiation, start talking about mediation, because the construct of our legal education is generating adversarial lawyers, you see. So the construct is different. We're working on that, but I'm just requesting the business schools to have a curriculum that integrates this into their program. It's imperative now that the business schools start talking about settlements, negotiations, and dispute settlements in this kind of vein. So specialized programs and practical experiences could be shared with students, and you can have a whole program collaborating with law schools, maybe, if you don't understand some aspects of it. But I think this would be important. I don't want to get into the details. I'm quite sure the business school will understand that this is mandatory. You need to bring that in. And you can find experts on corporate ADR all over the world. A big name is William Ury, Bruce Patton. Go read them. They're all there. And they're talking about businesses moving on in this direction. Nobody's talking about judiciary. Nobody's saying I need a lawyer to do this. Their companies are on their own. And this is the literature available in the market. Go read it. And you'll find number of leaders, thought leaders, sitting, talking about how companies ought to be moving themselves on dispute resolution. Dispute resolution is no more a court thing. It is our own thing, and we can resolve it there. The other thing that I want to highlight, an important point, is China. And I want to talk about BRI, the Belt and Road Initiative. I've been to China and I've been talking to them about it. I tell you, this is another big energy coming our way, and we need to capitalize on this. CPEC, BRI brings in a lot more energy, investment, employment, a number of things. Chinese don't like litigation. They don't like stay orders. You have to speak their language, and you need to understand how to do business with China. So China is a big business partner, and businesses in Pakistan need to prepare for China. And that can only be done if you have a language that understands dispute settlement, dispute resolution. You can't rush and get a stay order when you're dealing with the Chinese. They just walk away. So please start thinking on those lines, because that will bring a lot more investment, and China has already done it. If you go study their model, they have a China International Commercial Court, the CICC, they have a Silk Road Arbitration Center, which we can turn, I'm sure ADIRC could start working with them. The BRI dispute resolution mechanism is available in China. They don't want to impose it on you, but they want you to understand the language. How are we going to do business? So this is the language, the new language of business is mediation, pro-settlement language, which you need to generate. I can't do it as a judge, it's not my duty. You businesses will have to come up with a new language of dispute settlement. Please start working on it, start thinking on it, and that's how things are going to change. Because China, to my mind, is a big business that's coming our way. They're trying to work with South Asia, and the new thing that we're trying to do with them is that SAARC could be reborn with China, with the BRI, South Asia collaboration. We could start working with our neighbors with this new language of dispute settlement, enhanced trade, enhanced business. So please, for a minute, just forget the courts and start thinking about solving problems ourselves and moving ahead, speaking a different language and moving ahead and improving our the trade, business, which will of course move towards improving our economy, which is perhaps the key right now. We have to work on the economy. So we don't have to be reliant on any other system. We can do it ourselves. The businesses can do it, and I'm quite sure IBA's ADRIC could help handhold the businesses in understanding what we're talking about, and they need to understand, and I'm quite sure once they understand, they don't need us anymore. So that's all I wanted to say tonight. I also want to thank Justice Sarmat Osmani, who's sitting here, who's been my elder, my senior, and I've learned a lot from him. I acknowledge your presence with great thanks. Thank you for being here, and thank you everybody. I think it's about time to go home. Good luck and all the best to you all.